Hello, everyone. Thank you for joining us today. Today at the Fairhaven Lecture Series, which we're hosting virtually. I'm Carrie Bourne. I'm from the Office of Continuing Education at UW-Whitewater, and we have hosted the Fairhaven Lecture Series since 1983. We've had hundreds of presenters from our Whitewater and Rock campuses present to thousands of people in person at Fairhaven Senior Services over the years. But this year, COVID changed our plans, and so we're coming to you virtually through WebEx today. But we are pleased to be able to be here with you today, and thank you for joining us online. A few quick reminders. We are recording this session, so please be aware of that. Also, please do share your questions. You can use the chat feature. We'll address the questions at the end of the presentation, but please do feel free to add your questions at any time. We definitely like engaging with the audience the most. So enough of me talking. I'm going to go ahead and introduce today's speaker. Dr. Jolly Emery is an associate professor of political science and chair of the political science department at UW-Whitewater. She teaches courses on public law and American government and politics. She received her PhD from Emery University in 2002. Her research interests include law and courts, state politics, and interest groups. Please welcome Dr. Jolly Emery. And I think you're muted right now.
I'm the worst at that. So good afternoon. Thank you for having me. Thank you, Terry, for the very kind introduction. I appreciate it very much. Yes, I'm here to chat with you today. The title of my talk, as you can see on the slide, is Making Merit Your Legacy, How Justice Ruth Bader Ginsburg Achieved Greatness by Following a Path Well Paved by Another Great Justice, Thurgood Marshall. I'm wearing a mask right now. I'll be taking it off because I'm actually in my campus office, which is a space that only I occupy, so I can take it off in here. But I'm wearing it because I'm not sure if you can see it. It's actually got caricatures of Ruth Bader Ginsburg all over it. And it came to me as a gift in the mail on September 18th, 2020, which is the day that Justice Ginsburg passed away. So a friend who also teaches the same subjects that I do sent it to me as a gift, and it just, as a matter of coincidence, came to me on the day that she passed. So I'm going to take it off. I think you will be able to understand me much better without a mask on, and I'll put on my glasses because they won't seem up now. This is a picture of the court. You may have seen these pictures. They've been in the media quite a bit, but I am showing them to you now because, to me, they are so important in a symbolic sense. They have a habit or a custom in the court to drape the entrance to the chambers with a black silk drapery that is in recognition that a justice has passed away. And then you'll see that also her chair, where she sat on the court, is also draped on the back of the chair with this same black silk fabric. And the front of the bench where she sat has a black fabric draped too. Again, this is all to respectfully recognize that a justice has passed. And this is a custom of the court. One of the things that I did the day that I got the mask, the day that I learned that she had passed, was go to the court's website. And the justices had started putting statements up. These are the current justices serving on the court, as well as other justices that had served with her and who are now retired. And I read through each of the statements, and they were lovely. They were personal. They honored her. They included all sorts of language that spoke to all of her contributions as a great attorney and as an exceptional justice. In addition, they spoke to her as a human being. They referenced how warm she was, how welcoming she was when people, new justices, came to the court after she'd been on the bench for a while, and how important her friendship was to them. There were two statements in particular that touched me on a very emotional level. One, which I don't have here, was a statement that was made by Justice Breyer. And Justice Breyer actually wrote some verse that he said touched his heart with respect to her and her passing. My favorite, though, were just a few lines by former Justice David Souter. And he wrote, "Ruth Ginsburg was one of the members of the court who achieved greatness before she became a great justice." And this is so true. And I'm going to talk a bit about that. But I think it's important to understand, as the title of my talk implies, that she did have an example to follow. She had a template to follow that helped her to get to the court, and that was with respect to Thurgood Marshall. And so I'm going to speak to both of them and how they earned their seats on the court by merit, that they were both great before they ever became justices on the Supreme Court. If you are interested in these statements, if you'd like to read them, if you haven't already, you can find them at the Supreme Court's website, which I have here. It's supremecourt.gov. And it includes a statement from all of the current sitting justices that I mentioned before, as well as retired justices Anthony Kennedy, and then, of course, Justice Souter. Now, how did she achieve this greatness? Well, I've already alluded to the fact that someone else had paved the way, had provided an example, but it's not to diminish her work. Her work was, as I said before, exceptional, and I'll talk about that a bit, but it's always very helpful if you have a really good model to follow, especially if what you are doing as an attorney in particular is fighting for new rights, is working in an area where the issues may be politically controversial and where you have to turn to the courts to get these rights enforced because legislatures aren't doing anything about it. So I think it's always important to know this, and I teach this to my students. I teach it to them in my lower division courses and then remind them as we go through the upper division courses in the legal studies emphasis that appointments to the federal bench, whether it's at the federal district court level, which is the trial court level, the federal district court system, the circuit court of appeals, which are intermediary courts of appeals in the federal court system, or the United States Supreme Court, obviously the highest court in the federal court system, all of those appointments are political. They are all political appointments. Every single federal judge, from the bottom to the top, is appointed by the president and confirmed by the Senate. So part of getting on the court is who you know. Definitely part of it is who you know. But more importantly, it's who knows you. Who knows you and how you have made a name for yourself that gets on the radar of people who are important. So that could be the president, but it's more likely to be senators, because senators play a role not just on the back end during the confirmation process, like we're doing today with Amy Coney Barrett. Right now, just kind of fortuitously, I guess, or coincidentally, she is going through her confirmation process. Senators play a key role in identifying people for the president, that people who would make good nominees or appointees to the Supreme Court. So the president will rely on senators, and it makes sense. That's also a good political move on the part of the president. These institutions, they know how they work. The president knows that he, maybe someday she, will have to get the support of the Senate in order to get his nomination confirmed on the court. So they will turn to senators on the front end and other people they may know in the legal field to help them identify people who would be good appointments to the bench, to create their long list, and then they'll have interviews and a short list. And so it could be that people who get on the federal courts have been, kind of going up the ranks, so to speak. So someone could start on the federal district court, then go to the Circuit Court of Appeals, and then get the attention of key senators, perhaps the president or attorney general or other important political figures, and that attention then gets them on the short list to a Supreme Court nomination or the longer list. In addition, it can happen because you're just an extraordinary attorney. Not every person who ends up in the United States Supreme Court has judicial experience. Some of them have no judicial experience. Some will come from the Attorney General's office and then maybe go from the Attorney General's office to, say, Solicitor General. And we have many examples of that with regard to Supreme Court justices. And then some do, as I said before, kind of filter up through the federal court system. Some have been appointed because they are state Supreme Court justices. That was more so in the latter 1800s, maybe a little bit in the early 20th century, less so today. But they're all political appointments. It's who you know and then who knows you that gets you at least on the long list or the short list, and then finally appointed to the United States Supreme Court. So I want to start this comparison with Thurgood Marshall. I think it's important to understand what he did, what he went through with respect to getting his seat on the court, and how just as much as Ruth Bader Ginsburg merited, she earned her seat by merit to get to the court, so did Thurgood Marshall. And Thurgood Marshall basically created this very nice model that she could use because, as I said before, at the top of the talk, there is some similarity between the two of them in terms of advocating for rights for people that have been marginalized in our society, and using the courts as another venue for political goals because the elected branches were not willing to work that hard or had worked some that weren't giving full attention to those rights. So I'll talk about Thurgood Marshall right now. So this is a picture of Thurgood Marshall on the screen when he was an attorney for the NAACP. He worked for the Legal Defense Fund, which is a Legal Defense and Education Fund, I should say, which is the legal arm of the NAACP. A little bit about his background. So Thurgood Marshall was born, I think, around 1908. I think that's right, 1908. So obviously, Jim Crow was still in effect. We had a lot of segregation. So when he was a child going to elementary and high school, he went to a one-race school. He went to an all-black school. He was pretty mischievous, and as his punishment, and some of you may know this already, but I think it's kind of funny if you don't, as his punishment for getting into mischief, he would be required to read the U.S. Constitution. So I think that would be a great thing. That would not be a punishment. I would probably get into trouble just to get to read the Constitution. But a lot of people say that this kind of led him into thinking about the law and pursuing a career in law. Maybe it did. He later went to a one-race university, Lincoln University in Oxford, Pennsylvania. His brother had gone there, so he decided that he would go there as well. He then went on to get his law degree from Howard University in 1993. He graduated at the top of his class. And it's in 1935 that he starts to work with the NAACP and its legal arm, which is the Legal Defense and Education Fund. He eventually becomes their lead counsel, and this is where he begins to be seen. So as I talked about, it's not just who you know, it's who knows you. So this is where people get to know Thurgood Marshall. I tell my students this because I think that this is such an incredible statistic, and I do not believe that this record has been broken. While he was an attorney with the NAACP, Thurgood Marshall argued 32 cases before the United States Supreme Court. And perhaps even more stunningly, he won 29 of them. 29. So this is a Black person in American society, born into segregation, born into structural racism, institutional racism, who then becomes chief counsel for the Legal Defense Fund of the NAACP and ends up arguing 32 cases before the United States Supreme Court and winning 29. I think the case that most people are really familiar with respect to Thurgood Marshall and his lawyering is Brown versus Board of Education. And that is, of course, one of the most important cases that has ever come before the Supreme Court, and perhaps one could argue the most important case the court has ever decided. And I think, yes, it does deserve all those accolades. I think that without it, things would not have changed, even though it required later to have the help of Congress in passing the Civil Rights Act to get a lot of desegregation taking place. This put desegregation, Brown versus Board of Education, put desegregation on the political agenda, which it was so important because there was no place to go with regard to state legislatures, with regard to Congress, even for the most part, to get change when it came to all the segregation going on in education and other places of life for Black persons in the United States. But for me, I think with regard to Thurgood Marshall's lawyering, I think my favorite case that he argued before the Supreme Court is Shelley v. Kramer. And I'll explain to you why. But I also have a bit of a parallel that I want to use with Justice Ginsburg in a few minutes. So Shelley v. Kramer, if you're not familiar with the case, involved what are called restrictive covenants. And restrictive covenants were private agreements, private contracts that people would have within neighborhoods. And basically those contracts said that you were prohibited from selling your home in this neighborhood to anyone of a different race. So basically they were used to keep neighborhoods all white. And these restrictive covenants would have, they would be passed on from owner to owner. And some of them had 100-year long or 99-year long binding terms to them. Now, again, these were private contracts. So what Thurgood Marshall understood, and this is part of the reason that we got Brown v. Board of Education, was that the most important thing to have in American society to move upward, to have upward mobility, is education. So the Legal Defense Fund worked very hard to argue cases before the court to desegregate schools, including universities, graduate schools within universities, and then finally K through 12 education in Brown v. Board, because that's how you make a better life. That's how you have social upward mobility in the United States. And when you have that ability, when you have that education, you have that ability to move, to be mobile, you want to live in a better neighborhood, right? You want to live in a neighborhood with the best schools. Well, restricted covenants prohibited people of color from moving into these neighborhoods. They were prohibited by a private contract. In Shelley v. Kramer, it just so happened that this family moved into this neighborhood, a Black family moved into this neighborhood, bought a house, moved in, and then the next thing they know, Kramers come knocking, these are the Shelleys, the Kramers come knocking on the door, and they don't come knocking with a bundt cake or Jell-O or something to say, welcome to the neighborhood. Instead, they come with a lawsuit. And they sue the Shelleys because the Shelleys have moved into this home and they have violated the restrictive covenant, this private contract. So the NAACP and the LEF, they've got a bit of a conundrum here. In order to claim that the town, the neighborhood with this restrictive covenant is discriminating, they have to include some sort of government discrimination. It has to be something that government or an actor of government is doing to discriminate against you. People can privately discriminate all the time. And this was a huge problem because this is a private contract. This is not something that government was doing. This is not a policy or a law where government said, you can't live in this neighborhood. No, it was an agreement, a contract, binding contract among all the people who lived in this neighborhood. So Thurgood Marshall, he had to figure out what he was going to do here. And this is why I love this case. He realized that in order to have any kind of government action, so they could claim that these restrictive covenants that weren't just happening here, weren't just affecting people like the Shelleys, but were happening in many parts of the United States, that he had to have government action. So he sued in the state courts. And the case went up to the state Supreme Court. This is in Missouri, as a matter of fact. So the state Supreme Court of Missouri. And the state Supreme Court of Missouri said, hey, we can't do anything about this. This is a private contract. We cannot do anything to abridge this private contract. There is nothing, there's no government action here. There's no discrimination. The contract is valid. It stands. Now, you may think, wow, well, that's a shame. And sure does look like there's discrimination. And Thurgood Marshall and the NAACP must have felt bad, particularly the Shelleys must have felt bad. But actually, this is what Marshall wanted, because having the state Supreme Court say that there's no discrimination taking place here and that these were valid contracts became his legal argument when he appealed to the United States Supreme Court. And so before the United States Supreme Court, he argued that when the state Supreme Court of Missouri said that these are valid contracts and that there's no discrimination, that in itself was discrimination. That was government discrimination, because the courts are part of government, and that it was allowing for discrimination to take place. And the Supreme Court said, you know what, Thurgood Marshall, you're right. And he won. And the Shelleys won. Thurgood Marshall later gets appointed to the United States Supreme Court in 1967 by former President Lyndon Baines Johnson, who was, very active in doing many things to promote civil rights. And I think that this is also an example of one of his efforts. He had also appointed Thurgood Marshall to other positions in the government, but those were short-lived because when the seat became available, and it was Tom Clark's seat, I believe, Thurgood Marshall replaced Tom Clark on the court, he gave the seat to, or appointed Marshall, and Marshall obviously earned his seat. He earned it by merit. So I want to talk about another thing about justices before I talk about Justice Ginsburg and draw my comparisons. So justices share a lot of common characteristics. Most justices who end up on the Supreme Court went to prestigious private undergraduate institutions for their bachelor's degree. Obviously, that did not apply to Thurgood Marshall. Most all went to an Ivy League school. There are a few exceptions. Marshall is an exception to this. Also, I have to tell my students all the time, Stanford is not an Ivy League school. So there are justices who went to Stanford Law School, but that's not Ivy League. Even our own William H. Rehnquist went to Stanford, but he did get to the court. Stanford's pretty prestigious. If it's not Ivy League, it's still privileged and prestigious. Most justices come from a privileged background. Again, not Justice Marshall. Most justices have been white, still true. And most have been male, still true. And as I said before, the Senate plays a key role prior to nomination and then, of course, during the confirmation hearings. So the Senate is aware of all this. They play a key role in all of this. And you can think about this with respect to both Marshall's and Ginsburg's appointments, that they really are going against the trends of the tide as appointments go for the court over time. Oops, sorry. I'm having problems with this. Okay, so now to Justice Ginsburg. There's been so much written about her. She's a justice who's actually had a movie based on her, a major motion picture based on her. She's had documentaries, and well-deserved all of those things. So this may not be new information to you, but I think it's important to kind of talk about and remember, especially if we're comparing with Justice Marshall. She received her bachelor's degree from Cornell University in 1954. So, the year that we get the Brown decision, we have Justice Ginsburg graduating from college. Cornell is an Ivy, and she gets married that same year. The following year, she gives birth to her first child in 1955. She then enrolled at Harvard Law in 1956. So here we have a woman who's also a mother who enrolls at Harvard Law in 1956. And that's exceptional. As the slide reads, she was one of 9 women in a class of 500. So one of 9 women in a class of 500. There was a significant amount of gender discrimination that she faced while she was in law school. She was also criticized by a number of people for taking a seat that should have gone to a male. I don't know how that works exactly. I don't think that anyone sent a letter to her when she was accepted that read, well, we would have given this to a male, but we decided to give it to you. But please remember, this would have gone to a male. She was the first woman to serve on Harvard Law Review, and making law review is one of the most important distinctions a person can make when they attend law school. Her husband, Marty, got a job in New York City, also an attorney. He got a job in New York City, and they had to move. And so the family moved to New York City, and when she did that, she had 1 more year of law school left, so she transferred to Columbia to do her 3rd year. At Columbia, which is also an Ivy, she graduated first in her class. Now, it's 1959. She graduates first in her class, but the fact of the matter is that even though she's first in her class, she's still a woman. And I will tell you that Sandra Day O'Connor also faced similar problems after she graduated, but Ginsburg gets a few offers from a few firms, but they are low-ball offers compared to what her male cohort are getting as far as offers from law firms go. She is like getting bottom dollar. And so she decides to do some other work, and she goes to Sweden, and she's working on this civil rights project in Sweden, and also a civil procedure project while she's in Sweden. And she gets very involved in both these things. Most of her attention goes to civil procedure. And then she decides to come back to the United States. And when she comes back to the United States, she is going to teach law. So she's first a law professor at Rutgers, and then she goes to Columbia, her alma mater. And then she becomes the first woman to be tenured by the law school at Columbia University. Shortly after this, she begins working for the ACLU, and she begins working through its influential Women's Rights Project and taking on cases involving gender discrimination. This is where she begins to be seen. This is where Ginsburg begins to be seen. Her work through the ACLU leads her to being a very important member of its advocacy group with regards to the influential Women's Rights Project, and she starts to argue a lot of cases. As an attorney for the ACLU, and this picture on the screen is of Justice Ginsburg as a young attorney, she argued 6 cases before the Supreme Court. She won 5 out of the 6. So she argued in a couple of instances, there were other attorneys, that's common, but she won 5 out of the 6 before the court. The case that she lost is the case that I actually find kind of most interesting of all of those that she argued before the court. This was a case, the case name is Kahn v. Shevin, and this case involved a Florida law where if you were a widow, you would get a $500 tax exemption, but you would not get that tax exemption if you were a widower. And so the argument in this case, and this is why I find it so interesting, is that this law discriminates on the basis of gender. Now, on the one hand, you might think, well, yeah, but women are the ones getting the benefit. But for Ginsburg, the issue is important to understand that when it comes to gender discrimination, it doesn't really help anyone if you only look at gender in one direction, right? if you are able to argue that discrimination, whether the burden is placed on males or females, is unconstitutional, then you create further ground with regard to other cases coming before the court involving discrimination claims. So this is basically arguing, yeah, there's discrimination here. And so in this instance, as I said, they were arguing that the law discriminated because obviously it was treating men differently, widowers differently from widows. And the Supreme Court actually said, well, yeah, but in this case, it's okay. In this instance, it's okay because widowers are able to move back into, the workforce with ease. In fact, most of them don't leave the workforce. You have women who have been, who are now widows, who maybe weren't in the workforce or who had left the workforce and have a harder time finding their way back in order to, get enough money to support themselves, or if they have a family, to support their family. So as far as they were concerned, this Florida law was substantially related to an important government objective, which was to help women who face a harder economic burden when there is a death of a spouse than men face. So I like this case because I think that for her, she took what we commonly refer to, I guess, as a 30,000-foot view when it comes to discrimination and law that discriminates. Now, I don't know that she necessarily took that in every instance, but certainly when trying to build a foundation, when trying to get the court to develop tests looking at discrimination, it was really important for her to make these types of arguments. And it certainly gave her credibility and legitimacy with the ACLU and with the court. She is later, I think, as most of you probably know, appointed to the court in 1993 by President Bill Clinton at the time. So some commonalities between Ginsburg and Marshall. Both participated fully, once they got on the court, both participated fully in oral argument and in opinion writing. Both often wrote dissents, but they were very active justices. I think, by comparison, fairly or unfairly, Justice Thomas, who actually assumed Thurgood Marshall's seat, he has been criticized for not appearing to be a very active justice. But both Thurgood Marshall and and Ruth Bader Ginsburg worked very hard at their jobs. Both read through the petitions that came before them for review. They didn't rely solely on the work of clerks. And as I said, both participated fully in oral argument and both participated in opinion writing. Both worked to protect the rights of others who have been historically discriminated against. Thurgood Marshall with regard to Black persons and Ruth Bader Ginsburg with regard to women, but discrimination in general, but more so women and the rights of women. Both recognized that courts were another venue, perhaps a more welcoming venue for achieving political goals, especially for groups that are marginalized and do not have a lot of success with the elected branches of government. Both definitely added much needed diversity to the Supreme Court, and both were great, doesn't really, as it reads on the slide, capture this, but both were exceptional lawyers before they became great justices. Coming back a bit to some other things about Justice Ginsburg. So one thing that people have talked about for quite a while since she's been on the court is her friendship that she had with Justice Scalia, and they were very good friends. She's been asked about it multiple times by a number of media outlets, and they just respected and liked one another. And, even though they had ideological differences, they still saw so much that they had in common and enjoyed one another's company very much. So these pictures include pictures of the opera, so one of them riding the elephant that has been in the media a lot lately. And the picture on the left, bottom left, with, it's actually a parody, but it has Ginsburg and Scalia dancing. that one is one of my favorites. Just a little bit of an aside here. I've started to look at Irish courts. There's not a lot of work that's done on Irish courts, and recently Ireland had a referendum where they expanded their courts. They had an intermediate appellate court, and they gave their Supreme Court more authority. And a lot of their court system is modeled after ours, actually. And there's a rich history about that. But while this amendment was being considered, because it was a referendum, while it was being considered, the Irish Times ran a lot of editorials on the new authority, the new power that the Supreme Court would have under the amendment if it would succeed in the referendum. And one of the editorials had this picture of that has what is representing Ginsburg and Scalia dancing next to it. And they said, we don't want to be like the United States Supreme Court. And they thought that, you know, in this editorial, that the worst thing that could happen to the Supreme Court of Ireland is that they became like the United States Supreme Court, and you had justices who would go to the opera together or dance together or, you know, heaven forbid, ride an elephant together. I don't know. But I just thought that was pretty funny, that this would be the reason not to vote for that referendum. When in fact, it's the reason, I think, to appreciate so much about the court, particularly when compared with the other institutions. And I'll say a couple more things about that in just a second as I transition to the next slide. So the last part of Justice Souter's tribute or statement about Ruth Bader Ginsburg actually brought tears to my eyes. And so simple, yet so lovely. He wrote, "I loved her to pieces." And when I read those statements, and I read them all together, and again, as I mentioned at the top, that I especially obviously appreciated Justice Souter's statement and Justice Breyer's, but what touched me about every single statement that all of the current justices made and the former justices made about her was that they respected her so much. They recognized her for all that she did, despite the fact that many of them thought differently from her. Many of them held different ideological positions from her on a variety of cases. And they would write fairly, sometimes, I don't want to say heated, but I think of the Supreme Court opinions, including the majority opinion, concurrences, and dissents as a conversation among the justices. And they would sometimes take one another to task. And they certainly voted very differently, many of them from her. But every single one of them said such lovely things about her as a justice, a colleague, and as a human being. And I guess it struck me so hard because of what is happening right now in our politics. And I just thought, if only the other institutions could behave the same, if only the other institutions could separate out their differences that they have to argue about or have to represent in their work from how they treat one another as human beings, from how they recognize one another for the hard work that they do. And so those things were very important to me. And I think it's also why Justice Souter, who didn't always vote the same with Justice Ginsburg, why his quote meant so much and resonated so deeply with me. And so I guess I will leave it with that, and I will take any questions or comments that you may have.
Thank you, Dr. Emery. That was an excellent talk. I'm going to remind, we have a small audience with us, and it usually takes a minute or two for them to get their questions formulated in the chat. So I'll let them go ahead and do that. Please, the chat is in the lower right, a little message bubble, if you'll add your questions there. So one question I had was, according to her niece, I believe, one of her final public statements was a request to not fill her seat until after the election. Have have in the past, have justices made statements like that upon their deathbeds or upon leaving, or, how typical is a statement like that to come from a justice?
Carrie, that is such a good question, and I cannot answer that. I don't know how common that is. Justices leave the bench under a variety of conditions, right? So she was ill for a long time, right? So she was aware that she would be passing. I think other justices, their deaths while they're still serving on the bench are sudden, unexpected. And then justices retire, and some of them, don't say anything. They realize it's a political process, that the president has the authority to appoint someone to replace them. Sometimes it's strategic in terms of when they leave the bench. You might be looking ahead as a justice, like say you're thinking about retirement, you're looking ahead. You might believe that someone of the other party will win the election, so you retire in, your same party president's term, right? So if you're a Democrat and the president's a Democrat, then you would retire if you want to retire soon, if you're concerned about the appointment and that you don't give that appointment up to a Republican president. So that's a great question. I don't know. There's probably people who've looked into it.
Mm-hmm.
I can't say. But, people have been discussing whether or not she's being disrespected because these were her final wishes. Yeah.
Mm-hmm. And what about, it just got me thinking, those were her wishes. It was her seat, but it's not as if, and if she earns a seat, but it really isn't, her seat to decide, in some ways.
Right, exactly. And honestly, I think, let's say that it wasn't Ruth Bader Ginsburg who had passed away. Let's say it was, Clarence Thomas, okay? And let's say that he said the same thing, but you had a Democrat in office right now. Would it be likely or unlikely that Democrats would argue that he should wait? And it's an election year. He should wait until after the election. I think Democrats would say, look, fill a seat, right? It's an opportunity. And I think, again, this goes back to it's political. It all depends upon where you sit, right? If you're a Republican or you're a Democrat and who's in the office, what you want done. Yeah.
One question from our chat is, how often has the Supreme Court nominee not received Senate confirmation?
Okay, another really good question that I should probably know the answer to. It's happened a few times. Most recent history would have been Robert Bork. He was not confirmed to a seat. I think in the 60s there was Goldberg who was not confirmed. So I'm trying to think back. What else hasn't been confirmed? They're typically confirmed. Sometimes some are more contentious than others. Obviously, Kavanaugh's was contentious. Clarence Thomas's was contentious. Ruth Bader Ginsburg actually had 3 nays during the confirmation, Republicans, which makes sense. That's a really good question. Someone should have prepared more with regard to these questions. Yeah.
And, we're just getting to know the person who has been nominated to replace Justice Ginsburg. But from the little we might know so far, does it appear her path is at all similar to the one Ginsburg took, or are there any similarity? Clearly, she's nominated by a president of a different party, so we know there are differences. But are there any recognizable similarities besides the fact that she's a woman, and that sort of thing?
Well, they both taught law, so there's that. I think what makes her interesting is that she's in that column of they're not totally rare, but that column of less common nominees who have not gone to an Ivy League, right? Because she went to Notre Dame for law school and then she's taught at Notre Dame. She has judicial experience. You know, so they're very, I think they are very different ideologically. I will say that. Yeah. On certain key issues. Yeah.
So in this upcoming session, which cases bear watching?
So I think any case that involves, you know, Roe v. Wade. I think any case that involves that bears watching. I think cases involving voting rights bear watching, particularly any kind of redistricting case. But I am betting that a lot of the redistricting cases probably won't be granted cert, which means that when the petitions come before the court, all the justices get together and they vote on whether or not they want to take that petition as a case. And I'm betting, particularly with regard to political party gerrymandering, they probably won't even touch those, although it is a rule of 4, but with what potentially could be a larger conservative majority on the court, I'm thinking that it's going to be unlikely for many of those to go very far. You know, the court has just started its work, so they begin first Monday in October. Some cases that have been on the court's docket, they are continually adding cases to their docket, may be a little bit slower to go through the process because there is this kind of waiting game right now to see what happens with her confirmation. It's not that the court isn't going to do anything, but I think things will move a bit slowly for a while.
Maybe that's a good ending question in that if you were a betting person, do you see the new nominee being confirmed before the election or before the end of the year?
So maybe before the election, definitely before whoever gets elected takes office, right? So I think a lot of people at first were like, well, you know, after the election, then, you know, if she's not nominated or not confirmed, it doesn't matter. Well, no, because the new president will not take office until January. So there's plenty of time. You know, I hate to say this because there's such a good chance I'll be wrong with regard to which side I take. So I don't know. What do you all think? I think that the Senate, given its constitution, will likely confirm her. Yeah. And the president wants to move fast on this, and Mitch McConnell wants to move fast on this. So there you go.
Yeah, I think that's probably true. So I'm going to thank the members of our audience for attending, but I do want to thank you, Professor Jolly Emery. Thank you very much for being part of the series. And, you know, of course, we miss our in-person audience, but we are glad to be able to connect with them this way. And I will share that Professor Emery will be part of our post-election panel on November 9th. Who knows what we'll know then? Maybe we won't have a lot of results to even discuss, but we will invite her back along with a couple of her political science colleagues on November 9th. But thank you, Professor Emery, for joining us today. Thank you all in the audience for joining us as well.
Thank you, everyone, and thanks for the great questions. I'm going to look up those answers for you. So thanks.
Thanks all. Have a good night.